got personal service. He got served. I can
Ma'am,
bring that
I
into
don't,
the
I
court.
don't have, I don't know that because you didn't turn in
I'm
the
gonna
form.
bring it in. I'm gonna bring it in. I'll bring it in.
Okay, but you're telling me all these things and I'm just telling you, there's nothing else I can do. I set the date. So you think you can pay the 6,000, say by Monday?
Yes.
Yes. Okay.
Michigan's 14A District Court kicks off with an eviction twist already brewing. Sweetie Estates wants termination, but Suzette Hampton suddenly appears, claiming she moved out 8 months ago. Yet over $13,000 in rent is still demanded. Possession, money, and timing collide fast. Subscribe for more dramatic courtroom breakdowns.
The 14A District Court, County of Washtenaw, State of Michigan is now in session. All those having business draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning, folks. Court does call the case of Sweetie Estates versus Suzette Hampton.
Morning, Your Honor. Mustafa Hawili on behalf of plaintiff.
Are they here?
Not checked in.
Suzette Hampton? They are not here. Counsel, if you'd like to take a default, you've done the second service. Please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
All right. What is your claim in this case?
Judge, this is this is a complaint to recover possession of property with a supplement. Hold on, Your Honor. I believe Ms. Hampton is here.
I am here.
Okay, there you are. You got her. Okay.
Yes.
All right, Ms. Hampton.
Yes, sir.
All right. This is a case for termination of tenancy.
Your Honor,
What's your position on this, ma'am?
Your Honor, I moved 8 months ago.
You did what?
I moved from the property 8 months ago.
8 months ago?
Yes, sir.
You know anything about that, counsel?
Judge, yes, I did discuss this with my clients. They're not aware whether or not she has actually moved because there are still possessions that belong to her that are still on the property. You know how that works, Your Honor. The law says if she leaves anything behind, it's still considered possession under the law, so they couldn't go in there and empty it out. If she's claiming now formally that she left, Judge, then I would just ask the court recognize that and have my client take possession so they can go into the house and empty out her stuff.
She's indicating she surrendered possession.
Okay.
So she surrendered possession. They've also filed a money claim. That's going to get a bit complicated given the fact that if she moved 8 months ago, ma'am, did you give them keys?
Yes, sir. I notified Mr. Edelman and I had left the key in the mailbox. So, and we had on several occasions notified him and we got no response.
All right. So here's what I'm going to do. I'm going to indicate that possession has been surrendered. They're still, ma'am, claiming a money judgment against you. And how much are you claiming in terms of your money judgment, counsel?
Judge, $13,455.
And how much of that is rent?
All of it.
All rent.
Correct.
How much was monthly rent?
$1,495.
So about $1,500.
Correct. And I mean, Judge, I also don't want to complicate this on the court. If you want to kick out the issue of money for a couple weeks,
I'm going to kick it out.
Yeah,
I'm just trying to figure out what your claim may be claiming. If she left 8 months ago, and if they were notified that she left 8 months ago, I don't know if the claim for rent's going to be a proper claim.
And you and I are on the same page, Your Honor. That's why I need to discuss it with them.
All right. So, Ms. Hampton?
Yes, sir.
What I'm going to do is I'm going to adjourn your case out. I'm going to adjourn it out a couple weeks since possession is not an issue. I'll adjourn it out to, well, a few weeks. Let me adjourn you to the 20th. All right, March 20th.
Thank you, Judge.
2026 at 12 noon.
Okay.
That, folks, is an in-person hearing, so you both must be present here at the courthouse.
And then, Judge Simpson, my only request is if my clients decide they want to just waive this and dismiss it, I can file a dismissal and not have to appear, correct?
If you give notification to Ms. Hampton now that she's appeared that you're no longer claiming it, and
Okay,
we'll dismiss the money claim, and she knows that, I don't have a problem with that.
no problem, Your Honor. Thank you so much.
Thank you.
Hampton, thank you.
Have a
You're
good weekend,
welcome.
everybody. Bye-bye.
Bye.
Court calls the case of Blue Heron Point versus Justin Rowland. Hi there.
No, we have Ms. Haddad.
Good morning, Your Honor. Rania Haddad for the plaintiff. I believe that's a dismissal without prejudice.
This is a dismissal.
I believe so. I had 3
Cases-
cases today. Only 2 are going, so that's not.
Blue Heron Point versus Rowland. Rowland's not here. Case is dismissed on plaintiff's motion without prejudice. Haverhill on Clark versus Amy McDonald.
Good morning, Rania Haddad, 84927 for the plaintiff.
Good morning. My name is Amy McDonald.
Hello, Ms. McDonald. All right. Why do I have possession on these files? I don't. Those are not the terms we use. Hold on one moment. Okay, what is plaintiff's claim in this case?
Your Honor, this is a complaint to recover possession of property due to lease violations, specifically lease violations that resulted in police presence. So this is a termination of tenancy, Judge.
All right, Ms. McDonald, what is your position on this?
I submitted some evidence to the court.
Yes, I have, I'm not, so that you know, I don't have a context for what to do with all of this, okay?
I'm sorry.
So that's okay. And also, I don't believe.
Julie just gave this to me for this case.
Who this came from? Okay. So counsel, so that you're aware, I have probably, I don't know how many pages, and a flash drive and some additional documents. And it looks like another document may have come in. Okay, you didn't give a copy of any of that to the plaintiff, did you, ma'am?
I'm sorry, I did not.
Okay. Do you have copies of what you gave to the court?
Some of them, yes.
All right, here's what I'm gonna need you to do. I'm gonna need you to make copies of what you gave to the court. I don't know what we're gonna do with the flash drive. We'll have to figure something out. What's on the flash drive, man?
A lot of things that's gone on with me since I've been a resident of Haverhill.
Okay, I'm not sure I know what that means, but
Several of-
okay.
Excuse me, Your Honor. I've been trying to say this in a way that everyone can understand. I filed several complaints at Haverhill, which no one answered. And when I filed those complaints, I had to leave. So just to give you a little background, I've been calling.
Well, I'm not sure the background's gonna do me much good at this point. Because counsel doesn't have what's there. So you're gonna need to mail to council, and I'd suggest you do it today, given the situation with our postal service. The information, copies of the information that you supplied to the court,
Yes, sir.
all right? We'll figure out what to do with the rest at the next hearing. I'll adjourn this out to March 20th, 2026 at 12 noon. That's an in-person hearing, so I'll need the parties here. And then we'll figure out what we'll do with the flash drive if one isn't sent to your council.
I'm sorry, could you was that 12 p.m.?
12 noon. Yes,
Thank
ma'am.
you.
All right.
Okay.
Thank you.
Thank you. Excuse me.
Haverhill on Clark versus, is it Salida Jackson? Alicia Jackson?
Good morning, Rania.
Jackson. Go ahead, Council Secretary.
Or Judge Rania Haddad for the plaintiff.
Jackson, they are not here. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Judge.
All right, go ahead.
Your Honor, due to the defendant not appearing in plaintiff, sending out the second mailing or requesting the second mailing, we do move for a default judgment for possession. This is a complaint to recover possession of property due to multiple lease violations, including but not limited to multiple noise complaints and threatening behavior. And as a result of that, a notice to quit was sent to the defendant. So we do move for a default judgment for possession only, and we are requesting a writ date of March 9th, 2025. To my knowledge, the defendant is not a minor, incompetent, or in the military. And to my knowledge, the property has been kept fit for its intended use and purpose, and is up to code with all local and state health and safety codes. Excuse me. It's Friday, Judge.
Judgment to the plaintiff. That is by default for possession. No redemption amount. Writ to issue in 10 days.
Thank you, Judge.
Thank you. Propel Property Management versus Caitlin, is that LaRoque?
Michigan's 14A District Court kicks off with an eviction twist already brewing. Sweetie Estates wants termination, but Suzette Hampton suddenly appears, claiming she moved out 8 months ago. Yet over $13,000 in rent is still demanded. Possession, money, and timing collide fast. Subscribe for more dramatic courtroom breakdowns.
That's correct, Judge.
Your Honor, Adam Devlin, P 72877 for the plaintiff.
And is Caitlin here?
Yes.
Okay, all right. I tried to make no presumptions. He answered, and but I did. He could have been Caitlin. I didn't know. All right. Anyway, what's plaintiff's claim in this case?
Plaintiff's claim is that this is a non-payment of rent action, and after demand, there is currently due and owing $12,872.50 in rent. This is possession and money, so the costs are $329.50, totaling $13,202.
All right. And Ms. LaRoque, what do you have to say about that?
We did apply for the SER assistance through DHS, and then we can pay about half of that within the next week.
All right. So let's back up a second. You can pay about half of it next week, right?
Yes.
You applied for SER. Okay. How many people are in your household?
5.
5? Okay, so just so that you know, the state emergency relief with 5 individuals will only really pay about $870 if they pay anything at all. Okay, if they max you out on that. Okay. So, which is not nothing, but just so that you understand, it's not going to cover a great deal of this amount. Now you said, so how much is your monthly rent?
$1,400.
Okay. And how much did you say you can pay?
We could pay 6,000. We made a payment of 1,000 last night, and then we could pay another 6,000 within the next week.
Okay. Counsel, do you have the 1,000 that they paid in this figure?
No, Your Honor, I would have pulled their ledger last night. If you bear with me for 30 seconds, I can log into my client's accounting and verify their
Okay.
$1,000 payment. With all the fun of two form factor login.
These, are these on the one?
Yes.
Okay.
Your Honor, I do see their $1,000 payment.
Right, but the figure you gave me
It
had not
predates
taken
that.
that off yet.
Correct.
Right.
Predates. Yes.
Okay. That's fine. All right. So
Your
you,
Honor, I'd be inclined to
go-
adjourn this for their aid to come back for another pretrial and see if I can work out a conditional dismissal with them.
okay,
Especially if they're
that's what
gonna
I
pay
was.
$6,000.
Yeah. So when, folks, when can you pay the 6,000?
Whenever, Your Honor, we've had some issues with the payment method that they've made us use. So unfortunately, we have to pay in cash using Pay Near Me, and we can only withdraw about 500 a day. So that's kind of slowed us down, but we do have the funds. We can make
Okay.
those,
All right.
and we can make those payments within the next week.
Who are you?
I am Ryan. I'm also
Oh,
on.
okay. You're on the lease also? Because
Yes,
the case isn't in your name, and I'm just like, why is he talking to me?
Sorry.
Anyway, no, I'm kidding.
I don't mean to
No,
speak.
it's okay. It's okay. As long as she's okay with you talking, that's okay. But usually if the guy starts talking, things get messed up. I'm kidding.
That's funny.
All right. So you think you can pay the 6,000, say by Monday?
Yes.
Yes. Okay. So 6,000, I'll make that due by March 2nd. Okay. And then I'm going to adjourn this out a week. Actually, it's going to be 2 weeks because I don't have the 6th now available to me. So I'd adjourn it out to the 13th. See if you guys can work something out. All right. Let me ask you this. You're going to pay the 6th between the 2nd when you make that payment and the 13th. Is there any additional payment you can make?
Yes, Your Honor. We intend on getting fully caught up as soon as possible.
No, I got you. Do you know how much that would be?
Another 2,000.
Minimally another 2,000.
Okay, that's fair. That's fine. Okay. And I'll just say 2,000 by the 12th. Okay. Then I'll adjourn you guys out to March 13th, 2026 at 3 p.m. That's an in-person hearing, so I'll need you guys down at the courthouse, okay? If you work out, if you talk to counsel and see if you can work out what's called a conditional dismissal on that, okay? And see what we can work out. Not forcing you to do anything. If you come down to the court, we'll figure it out, but that's always an option for you, okay?
Thank you, Your Honor.
Thank you. All right. Guys, take care.
You as well.
Too.
Thank you, Your Honor.
Irina Politano versus is it Tyan Petrov? Politano versus Petrov. No response. Neither party appeared. Case dismissed. Kathleen Ivanoff versus Lauren Griffin. Hello. What's your name?
Kathleen Ivanov.
Ivanov. Okay. Lauren Griffin. They are not checked in. You did not pay for the second mailing or didn't do a second mailing, so I can't take a default today for their failure to appear.
Okay, he did get it. I just never put that piece of paper back to the court. I'm sorry. He got both.
What?
He got both summons though.
No, but there's a mailing that needs to be mailed by the court.
It was.
And no, it wasn't, because my file reflects the second mailing. There would be three services, ma'am. There would be a service that's basically a service by a person. There would be a mailing, and then there is a second mailing in order for me to proceed today with a default. That second mailing was not done.
By the court?
Right here, procedure takes center stage. With the defendant absent and proper mailing completed, the court grants a default judgment for possession only. No redemption amount, writ in 10 days. That's powerful. One missed appearance can cost you your home. Court rules aren't suggestions, they're everything in eviction law.
You did not pay for the second mailing for the court to do that.
Okay, nobody told me I had to pay for a second.
Well, I get it, but it's just not there, so I can't do anything. The best that I can do, ma'am, is to adjourn this out. I will adjourn it to my next available day,
Wait.
which is
okay.
March 13th.
Well, can you please tell me what I have to do? Because I was not told that I had to do something else.
Not at this point that I'm aware of. And I can't give you legal advice. I can only tell you that for me to proceed by default at the first hearing, you would have needed to do what's called a second mailing. That wasn't done. So I can't proceed with the default today.
Okay.
I'm going to adjourn it to the 13th, 2026 at 3 p.m. That's an in-person hearing. Ma'am, on this date, how much are you claiming they owe?
Okay, wait a second. Can you please go back? I do not, you have to tell me how to do this second mailing. When I went to file all this stuff, they told me what to do, and that was never part of.
They can't give you legal advice, ma'am. My clerks can't do that.
That's
So you filed the paperwork, right?
yes.
And that's how the case gets on the docket. So from the paperwork that you filed, there was a service on the defendant, which would have, see what the service indicates. Actually, there was no service on the defendant.
There
So did you
was.
have somebody serve them?
Yes.
Okay, that person, whoever served them, we do not have the return of service.
I know, that's my fault. He gave it to me to take to the court, and I didn't do it. That's my fault.
Okay, so that's not here.
I get
The
it.
mailing would have been done by the court, the first mailing, which was done by the court. We did that.
Yes.
If you wanted to take a default the first time around, you would have had to pay for a second mailing, which would have been done by the court. That has not been done.
Yeah. Nobody told me that.
Well, ma'am, that's why people hire attorneys or read the rules. I mean, I don't know my clerks can't give you legal advice.
Okay, as far as listen, I'm not trying to be argumentative. I've never done anything like this before. I've never dealt with the court. I've never had to do anything like this. I was following the instructions, and I thought I did what I was supposed to do. So I would not have thought of that as legal advice.
Ma'am, the case is started. So you did that. I just can't do certain things today because other things weren't done. But that doesn't mean the case is over. It's just, it gets adjourned out to a date.
Okay, so can you just at least, who do I call or who do I get in touch with to accomplish this through the court, this second mailing? And the other problem is,
Ma'am, I don't need the second mailing now. And the reason I don't need the second mailing is because the one hearing that the tenant would get, in essence, has happened today.
Yes.
Okay, so I don't need the second mailing at this point. Let me put it to you this way. If you had come in, filed the papers, the normal mailing would have been done by the court. If you had paid for the second mailing and the second mailing gets done by the court, then I'd swear you in and I'd take a default today. That's what would happen. It wouldn't automatically be adjourned out. That wasn't done. So what happens is it gets adjourned out if the tenant's not here.
Okay. So now what? So now what? You said I have to do this again?
Do what again?
Come back to court?
I'm setting it for March 13th, 2026 at 3 p.m. That is an in-person hearing. You'll need to come down to the court. They'll get notification of that hearing. If they're not here at that point, I can take a default.
Okay. He moved out. I have no idea where he went. And so if that gets sent to this address, I don't know how that's going to work. And yeah, so I still want the back rent.
I understand what you're saying, ma'am, but I mean, he's going to have personal service for me to issue a money judgment, but you know.
He got personal service. He got served. I can
Ma'am,
bring that into the court.
I don't know that because you didn't turn in the form.
I'm gonna bring it in. I'll bring it in.
Okay, but you're telling me all these things, and I'm just telling you, there's nothing else I can do. I set the date. You come down here. If I have all of the paperwork, you'll get your judgment. But I don't know what you want me to do, and I cannot give you legal advice. I cannot walk you through this procedurally.
I'm not asking for legal advice. I thought it was.
Well, you are.
Straightforward.
And so I will see you on the 13th at 3 p.m. Thank you. Court calls the case of Jeffrey Patrick versus Matthew Moore. Nobody's here. Neither party appeared. Case dismissed. Is that it? Thank God. All right. Court stands in recess. We'll be back for our 10 o'clock call.
At this moment, the judge balances firmness with flexibility. $6,000 due by March 2nd, another $2,000 before the next hearing. That's a lifeline, not a guarantee. Meanwhile, another landlord's case stalls over improper service and mailing rules. In this courtroom, paperwork mistakes hit just as hard as unpaid rent.